To increase coordination measure between police and judicial authorities in the field of judicial investigation and the prevention of terrorism, transnational crime and illegal migration. In 2005, a number of member states in Europe signed the Prüm Treaty in order to exchange DNA and fingerprint data and those convicted of criminal offenses and territory in the exciting countries. It was an innovative approach in the exchange of information between the police and judicial algorithms of the member state in Europe contained in the age program adopted by the European Council on November 2004. In 2008, the Council on Police and Judicial Cooperation codified an intergovernmental treaty which allowed member states to share data bilaterally across border. However, this too had entered into force before EU Lisbon Treaty, like the Prüm I, and therefore the role of the European Parliament in decision-making process was very limited. Furthermore, looking at the statistical data of the OCTA report conducted by Europol in 2017, it emerged that in Europe every year approximately 75 million people were victims of crime belonging to different groups, different nationalities, or operating in different ways and using different technologies. Since 2012, it has launched a specific cyclical programming on a 4-year basis, which then became permanent integrated in the 2020 into specific agency called the New Security Union Strategy, including the framework of the European multidisciplinary platform to combat criminal threats called IMPACT. Through this system, the number of arrests in Europe has risen enormously. Identification of the victim has also risen enormously. However, the excessive fragmentation in European legislation and also the 4 fundamental freedoms provided for Title V of the TFEU, Area of Freedom, Security and Justice, risk making all these instruments dangerous, dysfunctional. Precisely for this reason, in December 2020, the EU approved a package of reform called the Police Cooperation Packages, including Regulation 982/2024, called Prüm II. This regulation was finally adopted by the European Parliament in March 2024 and directly applicable by exceeding member states, everyone except Denmark. Prüm II aim further support national criminal investigation by adding to the automated exchange of DNA profiles, dactyloscopic data, and vehicle registration, also the automated search of digital facial images stored in national police databases, as well as giving Europol and its databases a strategic role. Member states shall ensure that index data on DNA, dactyloscopic data, facial images obtained from their national databases are available for automated consultation by other member states and Europol. Index data does not contain additional data that would allow the direct identification of person. Member states shall ensure the index data are available on facial images of suspect convicted person and were permitted by national law victims from their national databases established the prevention, investigation, or detection of criminal offenses. However, there must be offenses punishable by a maximum custodial sentences of at least 1 year under the law of the requesting member state. Member states shall ensure the confidentiality and integrity of index data by means of appropriate measures, including encryption. For the automated search of vehicle registration data, member states shall use European Vehicle and Driving License Information System, so ECARIS called. These data shall exchange via router equipped with a central infrastructure, include a search tool for simultaneous querying of national databases and Europol data, a secure communication channel between the central infrastructure, the component authorities authorized to use the router in accordance with Article 36 and Europol, a secure communication infrastructure between the central infrastructure and the European search portal built in compliance with a specific European regulation. The use of a router shall be reserved for the competent authorities of the member state of the Europol authorized to access and exchange this data. Upon receipt of a request for a query for a router, each request member state or Europol shall automatically, without and delay, query its databases. In addition, member state may decide to participate in the automated exchange to extract from criminal record. For the purposes of such exchange, participating member state shall ensure the available of national criminal record index containing master data set of suspect and convicted personnel taken from national databases established for the prevention, detection, investigation of criminal offences. Such datasets shall contain only available the name, surname, pseudonyms previously used, all pseudonymized, as well as data of birth, citizenship, country of birth, gender. They may be requested only for purposes of the prevention, investigation, detention of criminal offences punishable by a maximum term of imprisonment of the least 1 year under the law of the requesting member state. This data is exchanged through the European Criminal Record Index, called Epris, for exchange purposes, and even in these cases, all processing operations are recorded. The activities are defined if a match hit as a merge. Epris consists of a decentralized infrastructure in the member state, including a consultation tool that allow to simultaneous carrying of a national criminal record index on the basis of national databases. Here too, the applications are recorded and used exclusively for statistical research purposes as well as for monitoring and data protection. If a national authority has been authorized by national legislative measure, refer to Article 2, this regulation, it may carry out automated search through the Prüm II framework exclusively for the purposes of researching for missing persons in the context of criminal or humanitarian investigation or for identification of human remains. Through the router, member states have access to biometric data provided to Europol by third countries in accordance with the regulation in 2016, but Europol may also access data stored in member state databases using data provided by the third countries. However, in the event of match, Europol may use such data only with the consent of the member state in whose data the match was found. Data is protected. Indeed, each member state keeps record of the queries carried out with are used only in statistical research and monitoring purposes for data protection purposes, including the verification of the admissibility of the care of a query and the lawfulness of the data processing, as well as to ensure the security and integrity of data. Recordings are protected, unauthorized access with appropriate measures, and are deleted 3 years after they created. Data controller is EU LISA for the router and Europol for Epris. So, my conclusion. Many authors have expressed doubts about the application of Prüm II. It's true. Through the second, increase the automatization of data sharing, added new categories of data that can be shared, such as facial images, criminal record, and driving license data, standardize the format in which data can be shared, thus facilitating feature integration with other systems. Sets new standardize on data quality. It creates a legal basis for search for missing person and unidentified human remain. On the other hand, however, regulation Prüm II does not establish, for example, legal threshold to limit data sharing, such as the seriousness of crime, of which, however, Europol only provide a generic definition without specific details. And in deep analysis of legislative text reveals an intrinsic contradiction of the rules. Indeed, although the proposal for Prüm II falls within the scope of LED, that is Directive on 2017, that it provide a rule on the protection of personal data of natural person by the competent authority for the purposes of investigative crimes. In practice, it is difficult to achieve a coherent data protection regime for all EU police and criminal justice measures. It may be difficult, for example, to represent specific purposes limitation requirement in the general data protection rule applicable throughout the industry. In particular, Article 26 of a Council decision in 2018 on purposes limitation, which was deleted by regulation, the Prüm II, distinguished between two situations. First, the processing of personal data by receiving member state is permitted as a general rule. Only the purposes of decision exceptionally with the prior consent of the member state concerned. In practice, it is a question of preventing crime and maintaining public order and security and measure events. Secondly, and more specifically, automated data processing by research or comparison of DNA profile or dactyloscopic data is only permitted in specific circumstances, for example, to determine whether DNA profile or dactyloscopic data match, to prepare a police or judicial request for legal assistance if the data matches, and to perform log and recording. On the contrary, the lead provides for the possibility of processing personal data for the purposes of the prevention, investigation, detention, or prosecution of criminal offenses, of the execution of criminal penalties, is therefore remain very general. It does not take into account to a specificity of the Prüm regime, in particular, a regard to automated nature of the transaction. Other problem, it can also be observed that even after adoption Prüm II, this regulation, there continue to be several fragmentation between EU member states and the criteria for the detection and inclusion of forensic data, in addition to the inclusion and preservation of a profile of children and innocent people in forensic DNA databases. For example, some states include in the DNA bank only if the person has been sentenced to more than 2 years in prison. Other states add any person who has committed a crime, except in cases where the punishment consists of paying a fine. This raises legitimate concern, as some member states may process and store personal data with the principle should not be legally present in their system. In this complex context, there is also the different data protection regime applicable to Europe, whereby there is a lack of coordination between the legal framework and the regime, which also call into question the need for many of profile, including numerous national databases. From a practical point of view, for example, a person could be included in database in one member state participating in Prüm II and excluded in another, creating a mosaic of name with a different protection. Even the condition for justifying search a query of database different from one member state to another. These aspects are not adequately addressed by the Prüm II regime, with the consequence that persons registered in police databases in a member state were lower threshold for inclusion and less effective surveillance mechanism, and visage will be more likely to be subject to potentially unjustified police attention that the person benefiting from standard. In reality, that is, these people will be unfairly subject to the simultaneous increased risk of violation of their rights to due process, to effective remedy, as well as to privacy and data protection. For example, there are many alleged led violations from a procedural point of view. For example, the request member state does not have the possibility to access in advance the necessity or proportionality of search or accuracy of the data retained before the publication of biometric profile. The sensitive biometric profile of people who don't match but are still on the list will always be automatically shared for the purposes of making a comparison. Well-founded concerns have also been raised with regard to the facial recognition system due to the significant number of errors recorded in the correct identification of individuals. Other problem, the critical remarks already expressed, if there were to occur, would entail serious risk for fundamental rights, such as weakness and presumption of innocence, inability, mass surveillance, criminalizing migration through expansion to the other categories of data, exacerbating trends such as systematic discrimination in the police force upon the wider rule of law crisis in Europe, as well as reducing the control that citizens have over law enforcement and creeping police surveillance. Yeah. For example, the current Prüm regime, the European Commission has also observed an initial crisis of the rule of the law in Europe, often characterized by racism and control of minorities, the increasing criminalization of political opposition, refugees, migrants, as well as those acting in solidarity with the term by providing humanitarian aid, as well as investigate journalists. But however, we have, in contrast to that has been said above, authoritative opinion have been expressed in favor of the new regulation, arguing that it is precisely the automated exchange of data for police cooperation that will make it possible to combat both organized crime and terrorism effectively and on a daily basis, despite this concern, because national law enforcement agencies will be able to know more efficiently and quickly whether other member state or Europol have data linked to an ongoing criminal investigation, always limited to the prevention, detention, investigation of criminal offenses. Prüm framework has proved instrumental in solving many crimes in Europe, such as in Italian case of the murder of Chiara Gambirasio, in which judicial investigation relied almost exclusively of DNA profile. In addition, in accordance with the fundamental freedom of specific procedures, is provided for rectification the event of inaccurate data and for the immediate deletion of the data at the end of the automated response to the consultation, unless further processing is required for registration pursuant to Article 51, the regulation. In particular, the Prüm II Regulation will close the previous information gaps and promote security for all Europe also through the involvement of Europol and search on vehicle registration and data using criminal identity data. My conclusion. However, there can also be no doubt that the coordinated combination of the Prüm II legal system, the Epris platform, and the recent approval of the European Artificial Intelligence Regulation will strengthen the police ability to find missing and underfed person in EU, as well as identify unidentified human remain quickly and consistently. In fact, the prediction proves be to paramount importance, especially considering that more than 300 people disappear every year in Europe, according to data from 18 EU countries, of which only smart 4% of these cases are linked to criminal activities. In particular, the data collected show that since 2018, almost 17 migrant children have disappeared in Europe every day. We must not forget that the European Court of Human Rights has established the primary obligation of law enforcement agencies to protect the life itself. In conclusion, without the necessary substantive revision, the Prüm II Regulation could be annulled by the European Court of Justice, jeopardizing its state objective of finding crime in compliance with the EU law. Thank you all.